того, чтобы было больше ощущение какой-то беседы, возможность вовлечения в нее. С нашей стороны тоже произошли небольшие потери в процессе. Буквально с начала форума и до сих пор к нам, к сожалению, не присоединится коллега из оперативно-аналитического центра. Но Валерий Евгеньевич не пришел, но своих коллег попросил нам помочь в пределах собственной компетенции прокомментировать какие-то вопросы отдельные, которые мы будем обсуждать. Итак, меня зовут Татьяна Игнатовская, я адвокат. Информационные технологии – одна из моих специализаций, поэтому мне тут было поручено уже по доброй традиции модерировать уважаемых коллег и попробовать сделать нашу дискуссию относительно региональной проблематики развития интернета более, насколько возможно, живой и менее скучной. Мы долго пытались отойти и отказаться от презентации. В результате каждый из нас потерпел полное фиаско. Презентации будут у всех. У кого-то более интересные, ну, у всех, кроме меня, потому что я на правах модератора этим пренебрегла. Я надеюсь, что наши коллеги будут краткие, интересны, не дадут никому заснуть на, как правило, не самых интересных юридических сессиях. Итак, вместе с нами сегодня Ульяна Зинина. Кто был на открытии, уже ее видели. Ульяна занимается связями с государственными и общественными организациями компании Facebook. С нами Сергей Копылов, заместитель директора координационного центра доменной зоны РУ, правильно сказала? И Александр Жук, юрисконсульт компании Хостербай, наш белорусский коллега. Я предлагаю подключаться к дискуссии всем, кто есть в зале, с учетом того, что нас достаточно мало. Если коллеги позволят, возможно, даже задавать вопросы в процессе, пока есть актуальность и вопрос не забыт. Пару, наверное, вводных слов, как юриста, работающего в Беларуси, и как модератора этой же сессии год назад. Я, наверное, хочу отметить, что глобальных изменений в правовом регулировании белорусском за текущий год не произошло. В принципе, документы нормативно-правовые, которые регулируют непосредственно сферу перевозки нерегулярные, такие как такси, какие-то другие формы перевозок, известные, появившиеся на белорусском рынке уже достаточно давно. Теперь они находят свое правовое регулирование. То есть даже закон о защите прав потребителей больше не требует только бумажного документа, подтверждающего покупки. То есть тем самым признается, что даже подтверждение в электронной форме, которое, безусловно, не происходит без участия интернета, может быть достаточным подтверждением этого факта совершения покупки. Уходит сейчас, обсуждается изменение в положении о продажи товаров по образцам, к которому традиционно относится интернет-торговля. И это те изменения, которые появятся там, в течение ближайшего месяца-два. То есть сейчас этот документ проходит общественное обсуждение. И он также традиционно уходит только в сферу интернет-торговли, несмотря на то, что сохраняет свое название. Поэтому, забегая вперед, наверное, скажу и попрошу, чтобы Александр, когда будет рассказывать и делиться с нами своим опытом и своим видением, поделился теми предлагаемыми изменениями, которые со стороны бизнеса и со стороны Хостербая готовились и направлялись в ОАЦ в части изменения подходов и изменения норм, регулирующих регистрацию и другие вопросы, связанные с оборотом доменных имен. Ну и, наверное, заканчивая какое-то вводное и приветственное сообщение, я бы хотела передать слово Ульяне, и она поделится с нами вопросами регулирования искусственного интеллекта. Все мы пользователи, ну или почти все пользователи социальных сетей, и я надеюсь, что после того, как Ульяна нам что-нибудь интересное расскажет, мы будем больше понимать в том, каким образом социальные сети за нами следят, и в рамках ли это закона.
Спасибо большое. Я хотела взять кликер и на самом деле стоять, потому что, конечно, сидя я совсем не вижу свою презентацию. Еще раз добрый день, меня зовут Ульяна, я представляю компанию Facebook и являюсь руководителем по связям с государственными органами в нашем регионе. И сегодня я бы хотела просто кратко остановиться на проблеме, в принципе, развития технологий и то, как эти технологии влияют на право, законы и на, в общем-то, на работу юристов. Я думаю, что все из вас сегодня имели возможность пообщаться с прекрасным роботом, который в коридоре очень вежливо, так сказать, приставал к прекрасным дамам и не менее прекрасным мужчинам и просил сделать селфи. Кто-нибудь, все общались? У кого есть дома дроны? Окей. Одна Татьяна у нас такая продвинутая. Кто-нибудь... Полиция отобрала? Белорусская? Кто-нибудь пользовался системами искусственного интеллекта, машин-ленинга и прочего такого через интернет, какими-то сервисами? Кто-нибудь получал какие-нибудь юридические консультации с помощью ботов? Один человек. Два.
Получают юридические консультации с помощью ботов?
Окей. Ну, я хотела просто начать немножко с общего какого-то, скажем, боязни такой, которая есть, в общем-то, у людей, которые так или иначе сталкиваются с какими-то новыми явлениями. И если мы посмотрим там, на первую технологическую революцию, создание паровых двигателей, на вторую технологическую революцию, создание машины, как машины заменяли, соответственно, лошадей, технологическую революцию, в рамках которой был создан интернет, и все очень сильно боялись того, что это приведет к потере работы или что мы не сможем дальше, в принципе, существовать, то сейчас мы находимся, в общем-то, в самом начале четвертой промышленной революции, которая, в общем-то, характеризуется тем, что сейчас наши технические мощности и тот объем данных, который у нас есть, позволяет нам с невероятной скоростью развивать технологии, развивать инновации. И это совершенно новый и, в общем-то, пугающий мир. Потому что если мы посмотрим на все то, о чем я говорила, да, там искусственный интеллект, в общем-то, чаще всего многие из нас вспомнят про HAL 9000. Ну, многие, те, кто постарше, вспомнят фильм Стэнли Кубрика «Космическая Одиссея», либо те, кто помоложе, вспомнят про Скайнет и Терминатор, который, в общем-то, Скайнет, который всех поглотил и убил, в общем-то, практически все человечество. И на самом деле этот страх, он вполне закономерен, и это не что-то новое, что-то совершенно специфичное только для новых технологий. Один из моих самых любимых авторов, израильский историк Ноа Юваль Харари в своей книге «Краткая история завтра» «Homo Deus» пишет о том, что люди всегда исторически боялись всего неизвестного. И это на самом деле закономерность и такая константа, с которой нужно в общем-то, понимать, что это всегда будет. Но я как юрист и, в общем, как...
We always and look at technologies with great hope, with the hope that it's going to improve our life as an individuals and as lawyers. On the other hand, it's going to be super duper interesting because it's going to be very interesting for us to see what legal conflicts are going to come up with the development of like big data. For example, the services and apps that use big data to do facial recognition, and by doing so, they're going to limit or restrict the privacy. Yesterday I uploaded a selfie together with Sergey to the AI in the corridor, and Sergey was recognized right away. And Sergey did nothing, and yet he got recognized. So, what kind of legal restrictions could be used in order to ensure that the basic human rights are not violated? Moreover, bots, is legal advice provided by bots has any right to exist? For example, if you are advised by a bot and then the bot is mistaken, who is going to be responsible or take the fall? And for example, if a bot in Russia, there is a taxation, the taxation service provides such a service as a transcript or an extract from the legal body of text through Telegram. And what if the bot is mistaken and gave you wrong data? The next topic is the use of drones. Tatiana, who actively uses drones, as a lawyer, should ask herself whether drones are violating anyone's privacy if it goes by someone's window or over someone's head and record people who are in their private territory or are in their apartments. Well, there are some kind of laws regulating the use of drones, and there are areas that are prohibited for the use of drones, and I guess those laws are enforced, and it's up to you whether you're going to violate the law or not. Allow me to chip in. There are also software which is designed to fight against drones. So you cannot use drones in the airport, in the vicinity of airports, and there are some software that can limit the flights of drones. And there was an official meeting of the president somewhere in the area, and all the taxi drivers, cab drivers, on their screens, all of a sudden told them that they are somewhere in the airport, and you see that this software is quite effective. So, and this is the topic that has been faced by lawyers for a couple of years now. So we should keep in mind that there are laws that are aimed to protect the laws of privacy. Self or driven cars. Do any of you have experience of taking a ride in such a car? Well, in Europe and in Russia and in the United States, which goes without saying, is a very popular thing. And as far as the law is concerned and legal collisions, who is going to be responsible for the damages? I know you have an answer. Yeah, we have experience of liability, of administrative liability with regard to an unidentified person as far as the Belarusian law is concerned. Well, but as I said in my morning speech, I was sure that Belarus is a platform for like a beachhead of innovations. 2 years ago, if I'm not mistaken, there was a first case, an incident with the involvement of Tesla, which resulted in a fatality. And in the court, there was a court hearing, and the experts discussed who should be responsible for this death. Tesla, as a manufacturer of the software, the person who was in the car, or someone else, like a hacker. So those are the questions that you think you should think about. And what was the result? Well, they concluded that the person in the car was the one to blame, because a person who is in the car should always be vigilant and should be ready to any kind of incident. And the car did warn the person that a collision or a crash is going to happen, and the person should interfere in order to avoid that crash. And the person who was in the car was not quick enough to prevent the death. Therefore, the person was kept accountable. But it's all about the distribution or allocation of risks, how much the software designer should be held accountable for. So, and artificial intelligence, another topic, which brings up even more questions. One of the latest examples is the Canada's survey research. This is one of the recent ones, that artificial intelligence and the services built on machine learning can be biased with regard to different kinds of populations or population groups. For example, there was a case, in a very interesting, peculiar case, there was a beauty contest where an AI was a jury, was judged by AI, and it had to assess the photos sent to it, and none of the winners was a black person, was a dark skinned person. So the question was, maybe there was some room for discrimination there, and how we can avoid and prevent such discrimination in future. Well, let's go to law enforcement. They also use robots and AI, and you remember the classical example of Robocop, and when the AI will participate in making decisions, and I think that is going to happen very soon. So what we as lawyers can do so that the decision to imprison or not imprison a person, or punish or not punish a person, is taken without any prejudice, taking into account all the necessary ethical norms or all the circumstances that should be taken into account. Here I'd like to show you a video with a self-driving car.
So distant future, you're barreling down the highway in your self-driving car, and you find yourself boxed in on all sides by other cars. Suddenly, a large, heavy object falls off the truck in front of you. Your car.
So this is a classical logical syllogism, like a old dilemma from offline. So what a person should do in such a situation. And this is a Socrates dilemma, takes new shades and new meanings when an AI is involved. And if a car is driven by the AI, and the main question that I face frequently in my line of duty, and what I can observe in different countries, including our region, so what should be regulated here, and whether we should regulate those technologies, those legal relations in terms of us as lawyers, what kind of laws and what level of laws should be taken and enforced, whether it's going to be a national, central level law in Belarus, Russia, Poland, or it's going to be some kind of corporate norms in terms of service, each service, be it a Facebook or Google or Tesla, should have a set of rules by which they live and provide their services. Or it could be some kind of international mechanism, and what should go first, second, and third in line of priority, and whether the existing laws should be applied to those technologies and the resulting legal relations, or our old-fashioned laws adopted back in 1997 before all those technologies emerged. Let me give you a couple of examples about AI and robotics. In the UK, they are developing their own software, so-called digital strategy, to regulate these kind of technologies and to study what kind of ethical and legal issues arise. France is developing their own strategy. The European Parliament have also started thinking how to regulate those robots, and 2 years ago the European Parliament published a special draft report with recommendation to the Commission on civil laws on how to regulate robots. And I think it's not going to be a surprise for you that in their draft report they refer to the general principles of Isaac Asimov's the 3 laws of robotics, like a robot cannot injure a human being or through inaction allow a human being come to harm. And then the second, the third law refer to the first law. And in Russia, they don't have any dedicated draft laws. Well, they do have one prepared by Dentex, legal firm, and they plan to regulate robots as the subjects of law or legal entities. And there's also the issues of the regulation of AI is discussed in Russia. As far as Belarus is concerned, the closest thing we came to as far as the AI regulation is concerned is a decree on the development of digital economy, but robots are not mentioned there anywhere. But at least we have some foundation to work on, to build on. So there are a number of collisions with regard to what we should have more respect for, whether national sovereignty or the global phenomena and those technologies, corporate standards or the national regulation. So which should prevail, public safety or personal privacy, as far as the norms concerned. So in my opinion, the main thing that the lawmakers should strive for, and the expert community involved in the development of laws, is a balanced approach. In terms of AI, as far as the AI is concerned, I would like to emphasize a couple of key issues without which AI is impossible. As we have the enormous amount of data. The AI is based on machine learning principle, and it requires a huge amount of data on using which it's going to learn. Without that, none of the service is going to work. I have a service available through the internet, whatdog.net. So if I see a dog and I don't know what breed it is, but I would like to buy it, so I can take a picture, upload it to the portal, and the system, with some tolerance, the error margin is very narrow, like 0.1%, but it's going to tell me the breed of the dog. But for that system to identify all those small details and patterns and the links between all those pictures, the system needs to have access to a huge amount of data and pictures. Safety and security of AI and robots is
one of the pillars here. And now in Europe, we see a huge discussion about the openness of algorithms to understand how artificial intelligence is making decisions and to exclude any prejudice or bias, like no African American or Asian person, for instance. We need to understand that those algorithms are working well and they can be questioned if necessary. And another quote from my favorite author, from his most recent book that I advise everybody to reading, including Homo Deus. Now we live in times when all the existential problems faced by the world today are global in nature, like nuclear war, climate change, and technological disruption. These problems have only global solutions. And what I wanted to say in conclusion of my presentation is that when we speak about original specificity of how internet should be regulated and technologies should be regulated, we should understand that we cannot create something like something regional, like only Belarusian, only German, or only Russian, about a global technology, and be sure that this is not going to, these technologies will be allowed to develop further. Global problems require only global solutions. That's it. Another question, because there's certain lack of conclusion here. Is there experience of Facebook, for instance? I know that before that, big international companies were doing similar things when technologies and their swift development used by companies are in conflict with some local legislation in the countries where you're present. How do you behave in that regard? Going back to the question that the legislation might be lacking, or especially in our region there might be some post-Soviet vestiges of prohibitions and bans, then how do you go about that? When technologies at local level are blocked, or you're still looking for solutions? Of course, we are always premised on the fact that the more number of countries have access to cutting-edge technologies, the better would be the life of people. At least this is our ideal picture of the world, or ideal solution. In other words, the more people have opportunity to use, say, augmented reality glasses and do training with these glasses in the best institutes and universities of the world, then the country and its youth will be better off because of that. And all countries are prepared to introduce such technologies, or rather, there are some unliftable restrictions. Sometimes we see softer policies and recommendations that we have to work with. And this is the work that we do in different countries with AI, which is used in Facebook quite actively to delete terrorist content. So our AI-based system immediately recognizes the patterns of Islamic State and deletes everything related to that without operators' involvement. In all those countries where there are restrictions in the use of such systems, of course there are some restrictions about it. When there is a certain block and we're talking about recognition of faces, like Sergei Koplov's face is recognized there, and if the local legislation, for instance, prohibits the use of such form of such activity of a user in social media, for instance, then the non-use by company of Facebook of such technology in the country is not going to bring any good or bad. When it's prohibited, it's prohibited. But when we're saying that there is some terrorist content which is blocked by Facebook by default everywhere in all countries, but at the same time there are some local restrictions at the level of local regulation, how do you behave yourselves then? Because in any way, deletion of terrorist content and the existence of sometimes could be in conflict that the company must make a decision of whether it keeps certain social responsibility in terms of non-distribution of prohibited content in principle, or at the same time they're violating local legislation. Do you sometimes make such a choice? In any way, the company acts in full accordance with the community standards that we have and the principles based on which which describe these community standards, and whatever is prohibited by community standards. So Facebook is prohibited globally without any differentiation of one area from another and different jurisdictions. If there are some strict contradictions about non-deletion of, say, Islamic State, again, terrorism is the most obvious and generally recognized category, although despite the fact that there is no single definition of terrorism, there is a certain list of countries, or rather organizations, which are recognized by UN as terroristic, which we delete by using our technologies. All the rest, we have to find a compromise to make sure that users in different countries can have equal level of protection and level of service, quality of service. Thank you very much. I'm sure you will get in. You will contribute more to our discussion now. We'll be moving down to more down-to-earth, more mundane, but maybe more interesting things that different entities encounter when working internet, which is the problem of delegation of domain names, and some problems which might appear when actively behaving in internet. Sergey, please share your experience because you're a well-known person in this field and you're very vehement speaker. Yes, I would agree with you. If we compare the size of internet of Russia and Belarus, it's like comparing my size with Tatiana. We have more internet, we have longer internet, and we have passed that way of road which was full of pitfalls that I'm going to share with you. The main sense of legal regulation of internet, in our case in Russia, at the moment we all realize is a prohibition trend. We under a constant narrowing down of allowed jurisdiction of how to use internet and allowed content in internet technologies in internet. They keep trying to restrict the legislative norms. If we look at what has been adopted recently in Russia, we see many laws which were, one way or another, affect the use or development of internet, both from the providers and users. And everything is done within the framework of the law on information. De facto, we have internet law, though originally it was called information law. Now we have a trend when all the prohibition norms, almost all of them, are included into this information law. And from its own innocent regulation of information, it has turned into internet regulation law. This law was adopted. It was the so-called anti-piracy law in terms of a violation or infringement of copyright in internet. It was anti-piracy law. The new way of blocking sites was introduced for the violators, where an interested person could get necessary measures undertaken. Everything was covered by Roskomnadzor, or a special watchdog of Russia, who were preparing blacklists, filter through which the providers could upload the kind of links and insert them into their filters. We need to understand one simple thing here, that legislative definitions and technological definitions are totally different, which changes the overall picture of the world. If lawgivers consider it site blocking, technicians understand that it's not so. Sites are not disappearing, they continue working. And this is why we adopted new laws afterwards. Because generally speaking, they don't block the sites whose technologies are applied in Russia, but they filter the requests of users to get access to those sites. In other words, all the prohibition measures are working at the level of your internet access provider. When the internet access provider is studying your traffic and they see what requests you're sending out, when they see the things or addresses which are included into the blacklist of Roskomnadzor and which is synchronized with the filter of the provider, then this requests are blocked and they're not going anywhere. So once you circumvent this filter and you visit those sites again and watch them, it looks like you're not breaking any laws, because it's up to the provider to ensure the blocking. And the technologies are not standing still. The technologies are getting simpler. Now all the well-known browsers have issued an addition which can simply be downloaded by lazy school students, and it's enough to punch one single icon and then forget about all the filters, because with proxy and VPNs and ciphering of traffic, you can circumvent everything. For users, this might be good. On the other hand, from the standpoint of regulation, it's bad, because the achievement of the goal is replaced by the visibility of this achievement of goal. And there is a tech joke when you put on airs that you block site, and we put on airs that we don't visit it. Then new laws were adopted to fight extremism in internet. It's all about blocking. The amendments to the law on personal data, which established for the operators of personal data a mandatory obligation to keep the personal data on the territory of Russia, so that the database must be kept on the territory of Russia, from where you can send out those data wherever you want. But the actual database or server must be on physical on territory of Russia. The main package, the so-called Yarovaya package on anti-terrorism amendments, it was about organizers and distributors of information, where any chat, any forum, any social media could end up under the jurisdiction of this law. Additionally, they expanded the copyright law. This is the law on lifelong prohibition, oblivion law, and the social media law. So in Russia, they adopted too many things when they practice already demonstrate that some things simply don't work, and some laws had to be abolished later on, like the law on bloggers, for instance. We used to have a law on bloggers in Russia, according to which dedicated bloggers should be included in the special registry of Roskomnadzor, or the watchdog of Russia, and be in line with certain set of requirements. I must tell you that this is the only law whose abolishment was not welcomed by the blogger community, because it's strange as it seems, it turned out into a trend, because bloggers really were looking forward to ending up in the list of Roskomnadzor watchdog. Anyway, I have a copy of this presentation. So now, blocking of sites. Why am I talking about these measures of the Roskomnadzor watchdog? Here, the coordination center started to pitch in, because extrajudicially they start to adopt their own measures. Why? Because they invented the so-called lifelong blocking of sites, which repeatedly infringe copyright law. It looks like a fine thing to do, but the principle of this amendment was very simple. Any repeated, with a repeated filing of documents to Moscow court, the filter is switched on permanently. URL and domain name are included into this blacklist registry. Good domain names were included into the permanent blacklist, but they forgot to synchronize this with all the domain names of coordination centers, which meant what? Those domains were started to be sold on the market. As soon as it ends up on the market, the seller of this domain said, see what great domain name I have. They sell it for huge money, and the new buyer finds out that this domain name cannot be used in Russia. And now they had to admit or adopt new laws according to which these domain names are included into the stop list to prevent their reselling later on. Now we have an extrajudicial way of blocking the sites. Ministry of Communication is making a decision on the merits of the sites, which are already blocked. And you have read in media already about this filtration, like that LinkedIn works with some people and it doesn't work with others. Usually when I ask this question to tech people at different conferences, I ask them, who is using LinkedIn after blocking? Everybody raises their hand. Basically, it means that it keeps working. Everybody knows how we were fighting with Telegram. Amazon, Viber, and Odnoklassniki suffered a lot because of this when we were blocking IPs by millions. Now the main sphere. What is the trend here? The main trend here is that the right users, right owners are working through some of the decisions. In one of the court decisions, they said that delegation can be removed for blocking of pirated content. Now they start suing registrars as information intermediaries. Those people couldn't know who information intermediaries are. Is the person who can put a stop to the access of any site. If they don't do this, then extrajudicially they can be prosecuted along with the violators. So it's clear that the copyright owners want to strengthen their rights, but this way they're actually attacking the whole infrastructure. And now we have a new trend by using different means and methods to put a stop to delegation of domains. The coordination center, of course, here, the rules adopted by the coordination center. They look at the trademarks and domains passed on according to the court decisions, and they do by registrars. And also we have grounds in the rules delegate domains, which I can tell you work not very well. This is bullet point 5.5. Bullet 5.5 was originally designed exactly for law enforcement agencies to remove delegation from domain, so that the domain stops referring you to illegal sites. Unfortunately, this bullet point 5.5 remains to be unenforceable since the abolishment of the Drug Enforcement Agency, which is now under the jurisdiction of the Ministry of the Interior, and they use different means of starting a criminal investigation. This bullet point stopped working in principle, but now it works. We have an extra judicial way of prosecuting computer crimes, like botnets, phishing, and also we have historically child abuse images. Moreover, this is the network of competent organizations that I told you about at the previous conference. When you come to register and confirm that such and such domain is carrying illegal information. Why? Because here we need to have immediate response to this. One of the most popular phishing sites, for instance, is down there. See, it's not really difficult. Put in the number of your card to verify the security level of your card. CVC also needs to punch it in. This is one of the most popular sites. People punch it in and then they're surprised that you're losing money. That is why we have 5.7 bullet point according to which such sites can be, I'm sorry, not sites, but domains can be easily blocked. We can fully block this domain because as a rule, all the referrals are to this domain.
Moreover, so in our system, in the extrajudicial system, 3 more powerful organizations joined in. It's Sberbank, Central Bank, and Roskomnadzor watchdog. So they realize that our system is much more efficient than the legislative one because it's quicker. The second problem is the identification. Sometimes we have these kind of scans when we request documents. This is a growing problem. We are going to have some legal regulation of this issue, not only as far as the register is concerned, but any internet service. And why this problem is growing? As you can see, you can be surprised, you can laugh at it, but smile at it, but imagine that there is your photo and your passport data is there. You don't need a scan of the passport to make a copy of an identity. And if you send this ID copy and register some kind of illegal website, then you're going to have to explain yourself to law enforcement authorities and explain that this is not you. They first going to arrest you, and then from the detention cell, you're gonna explain them that this is not you, because all the law enforcement systems work to the same principle. You first find the scapegoat, and then you have to prove that you're innocent. And this problem is going to grow, and is going to require legal regulation. This is it from me. Thanks. So I wanted to clarify one thing. You mentioned that one of the trends is the cessation of delegation as a way of blocking. Is it a practical practice or a trend? Well, this is a wishful thinking. Now this is the copyright owners want to do, and their wishes are growing and becoming stronger and stronger. We would like you to, they say, we'd like you to cease the allegation at first request, and like pirated content on some website, violation of a trademark in some kind of domain. You first cease the delegation at our request, and then we're going to have a court hearing. So we are against the registrator acting as a kind of lawmaker, because as far as addressing is concerned, and you're familiar, the domain identifies the IP that is used. So this is a part of the registration information. And if we use technologies in that way, the domain also participates in the addressing. So you can say, but router also is part of the addressing. So why not submit your request to the manufacturer of the router, to the network cable? Why not go to the energy company, because they have the general switch that participates in the addressing of the entire internet, because if you turn it off, nothing is going to work. So this is the kind of arguments they use, but we are trying to defend ourselves. Does the coordination center of domains tired the copyright owners with their enthusiasm and with their proposals, with fresh proposals regarding the subjects of law? I'm going to use my diplomacy here. So I think the demands of copyright owners are excessive compared to those mechanisms that they have. That's it. Maybe the reason is that the legal defense a remedy is a very long road that you have to take to defend your copyright. Well, but the legal hearing is a law, and with a remedy provided by law. So we have a law on piracy, and you have some positive legal practice, court hearing practice. So if you want to change something, go and change the court practice, go and change the law. You already have some tools that you use, and you want even something more, but they say those tools do not work. And I'm telling them a joke as a reply. So back in the USSR, and the two guys who go to a store that sells liquor. One counts the change, the money, and it's 5 minutes to closure. And they give the money, and then the window closes. And at 7 o'clock. And then he looks at his money, and then hits his friend, and the friend says, "What for?" And he said, "What else should I do?" That's why the supervisors and watchdogs, they try to use all these tools without thinking about the rationale behind using them. So I wanted to ask you a question. Maybe you'd like to comment first on what you heard, and then I'm gonna ask you my question. But I would like to say your opinion, being the representative of a regulator. Do you think it is feasible to extend the grounds for blocking access to the internet resources, websites, whether the copyright owners' demands are justifiable in terms of the state regulation? I'll be talking from here. My name is Evgeny. So it's the first time that it's not the first time that I heard about these arguments, so I'm keeping track of the Russian laws in this area. I first like to comment, and then I'm going to answer your question. I have my question of my own to Sergey. So as far as I understand that it's not about the restriction of access, it's about the content that is violation of law. And there was a decision made in Russia. So if we have a content, let's restrict it. And then the blocking mechanisms appeared. So my question is whether the Russian Federation considered other approaches to solving the issue of content instead of blocking it. Well, I do realize that the most efficient blocking, not filtration, but blocking, is at the source end of the content. There were attempts made to I heard about discussions that did not translate into draft laws. There were attempts to unite so-called abuse community when major registrators, major hosters wanted to agree on something. There were attempts when they wanted to unite their hosters into some kind of community in order to be able to block the contents at the source. There are some positive examples when the international community agrees on working according to certain rules, and those rules work. Not sometimes, they do not work all the time, but let me give you a spam house example. When the work with spam using international efforts became an international list of spam addresses. And our market participants are afraid of it. If your company gets in that list, your spam is not going to reach the prospective clients. So I saw that Uliana wanted to speak her mind. Well, I wanted to say that blocking is not a universal cure. And we all know that blocking of content at the provider level, registrator level, entails a lot of negative consequences and does not solve the problem at all, because VPNs, etc., the content can still be available. And if we take European American experience, since 1995 they have the MCA, which sets the criteria for responsibility of platforms, where the sites themselves are responsible for removing the content. And this attempt was made in Russia. In the civil code, they included a couple of years ago the rules regulating the responsibility of the hosts, the information mediators, so-called. So if you didn't know about the content, about the illegality of contents, you are not responsible. But as soon as you realize that the content is illegal, then you become responsible if you haven't removed it. So the Russian civil code has it. Unfortunately, it does not work. As Sergei said, everyone is looking for a quick solution, and they think that that solution is the best solution there is. And the copyright owners think that despite all this lawmaking waste and garbage that they have, the copyright owners still think that it's not sufficient because it doesn't work. So I'd like to add here that it doesn't work for two reasons. First of all, it does not match the technologies, and the protection of intellectual rights is a very profitable business, and I'm sure that the defenders or protectors themselves think that it's not profitable to use one remedy to close or block some kind of contents, because otherwise they're not going to earn money. So my name is Sergei. I'm from the youth program. We are the technical administrator of the buy and bell domain zones. I would like to emphasize what Sergei said about the Russian practice. Yes, there is a there are competent organizations that can signal or send warnings to the registrator and to block the illegal activities right away. So I think that our guidelines on domains is not perfect, because we do not have quick tools to block things such as phishing to sites or child pornography. So even when we have like blatant violation of law, the current tools does not allow us to remove the domain from the register or seize the delegation. So we were going to discuss this issue with Alexander. So Operations and Analysis Center. So in guidelines regulate domains and names, because there is a domain name and resource, two different notions. And as Sergei mentioned, by seizing the delegation or removing the delegation from domain, this is not the most efficient way of blocking certain content. And, well, there are some lengthy procedures for solving domain name related issues, but here we're talking about the domain name specifically. And if the rights of the copyright owner are violated, it's about the violation of the name itself, not the content in the domain. If there is some content related to the administrator of the domain, we have such thing as the use of the domain name. This is like a very speculative thing, because the resource of the administrator of the domain should be used. But as far as the rest is concerned, the guidelines regulate the domain name and not the content of it. So we're talking about the imperfect mechanism for regulating the domains. So one more question. We need to first switch on the microphone. So I'm the mobile communication operator. Sergei, my question is to you. If blocking if it turns out that the blocking is illegal or unlawful. So who is going to pay money for the damages? Okay. My first answer is no one. My second answer, as far as I remember, and what about you, Juliana? I do not remember one single case of unlawful blocking of a domain. Well, as far as phishing and child pornography is concerned, and sub-networks, I don't remember a single case when they told me that when a domain was blocked unlawfully. There were cases when a domain was blocked and the owner came to us right away and asked us why did you block us? And we said that you have a vulnerability and used by the hackers. They remedied the situation and the domain was back online. So it's copyright, but we don't have any blocking related to copyright. Filtration goes from Moscow City Court, and if there is a court decision, that's where you should go. But what I want to say that the practice showed us that no one comes to Moscow City Court when those issues are resolved, issues of blocking. And the complaints are usually submitted to foreign hosts who never come here, and those who come, when the domain is blocked, they adjust the content, and the Roskomnadzor, watchdog organization, then remove the blocking. So the process is well greased and operational. Well, maybe the mechanism is well established, but there are very single cases of the situation happening, the situations that you described happening, of who is going to be responsible. So I don't remember indeed any cases when there were unlawful blocking of a content. And Telegram was blocked, if you remember. And after one of the services was blocked by Roskomnadzor, because it allowed access to Telegram, they filed a suit. Why did you block us? And there was a case too when there was some kind of educational portal was affected because they had an IP address belonged by a pool of IP addresses which was blocked because of the Telegram blocking, and the website was blocked, and they filed a suit, a lawsuit, and they went as far as the Supreme Court, and the Supreme Court ruled, said that they were innocent. But when the case on blocking was considered, so the owner of the website should be invited to the court hearing. At least that what they achieved. But let's be honest here, Sergey, this will not save the father of Russian democracy. So this VPN service that was blocked in the court, they told him, "Oh, well, I'm sorry, but that's how things are. That's what happened. And the fact that you were blocked and that the educational website was blocked, well, this is the collateral damage, and you have to accept it. Nobody's to blame for it." First, remember, nobody forgot about a thing as the recovery of lost profits. Because I guess Russian courts are not very fond of lost profits, but it's called past liability, and the cause and consequences relationship here is very complex, and you can use lost profits only to commercial websites, and if you are not a non-commercial website, if you were like blocked and lost a couple of million viewers, you'll catch it up. But the question is, who will be recognized as the person who's to blame for it? Yes, that's a question that yet has to be answered. So we need to track the changes, keep track of changes. Maybe someone will be able to recover lost profits for the last 3 million views. Hopefully we'll be able to discuss it in a couple of years at the IGF conference. While we still have time, I'd like to give the floor to Alexander Zhukov, who was going to give us a brief overview of the changes in the laws and trends in Belarusian regulation of the internet. Alexander, would you please tell us also about the changes to Act 47, which is the decree on the regulation, delegation, and revocation of delegation. So what were the proposed changes, and how they're going to, whether those changes are going to be adopted? Well, there were no proposals yet. Within the organization, we developed those proposals, we stored them, and we were going to discuss them later. So there will be a debut on the improvement of instruction or Act 47. I'm going to support the Belarusian stereotype mentality that our legislation is not that developed, and my speech is going to be very short. So let's start from Decree 60 and Resolution 644. Are there anyone in the room who is not aware of Decree 60 and what it's all about? Okay, we have maybe they are like foreigners here, our guests from abroad, overseas. So in Belarus we have a Decree 60 of the President, dated 2010. So this decree introduces an obligatory hosting of legal entities and individual entrepreneurs, and the legal entities in general who sell goods and provide services or offer jobs. And
if such a legal entity is doing such stuff, they're supposed to host in Belarus. Consequently, this decree gives rise to a number of conclusions, like, for instance, we have received explanation. We believe that there is a number of persons, like self-employed people, who are not individual entrepreneurs, which include also lawyers, notaries, craftsmen doing agro-ecotourism. They provide services per se, but as long as they're not individual entrepreneurs, no legal entities, they're not listed in the decree number 60. In other words, they could have hosting beyond the territory of Belarus. So perhaps will analytical center will listen to us and will cover this gap by amending this decree. In fact, until nowadays, we still have an open question, not only about the mandatory existence of hosting on the territory of Belarus, but rather the issue of registration on the site of Belgia. In Belarus, there is a Ministry of Information and Informatization, under which exists the Belarusian State Inspectorate on E-Communications, Belgia, as we call it. And in Belgia, we must register the information resources. And there are a number of views on this. My personal view is that the registration of sites, the sites of physical persons in Belgium, should not be registered. But in my opinion must be different from the opinion of, say, state authorities. Directly speaking, the owner of the site cannot register it in this inspectorate. They can do it only and exclusively through the supplier of internet services, because the form of registration, in fact, presupposes some data passed on by the internet service suppliers, and they mention the name of the person who is registrable, should be registered in Belgium, but decree number 60 and the resolution 644 do not mention this. So this is an open question that I'm personally concerned about, whether these sites are subject to registration in Belgium or not. So this is one of the curious things here. Next question is about non-commercial organization, NGO, providing services. Formally, it is a legal entity in this case, but they don't get any profit because they're a non-commercial organization. Then, would that non-commercial organization have to be hosted in Belarus or not? From direct interpretation of this, they must be hosted here, but it doesn't sound logical to me. As Tatiana asked me, instruction number 60. This instruction regulates how domain names are to be registered in Belarus, and the presentation of those changes that we've been working on, that we were thinking about. Alexandra, let us be very exact in formulation. It's no longer instruction number 60. Yes, it's instruction number 47. I agree with you. My mistake. Now, what are the main questions that we have here in changes? The main question was not included into this list. We have bullet point 3, instruction number 47, according to which it is not allowed to have sites whose domain name is registered and it's registered for the use. This way, out of this, we have a conclusion that if the domain name is not used, then it must be taken away. If it can be taken away, then later on it can be resold through the auction. And in principle, what I think about it, it's not really correct, because in principle it violates the right for free use of property rights. So if the domain name later is resold for bigger money to cyber squatters, that's one thing. But when the domain is registered and not used, I believe there is no right to take it away. Can I ask you a question? What do you imply by non-use of a domain name? Lack of a site? Yes. If, for instance, not only the non-use of this or non-existence of a site, like for instance, if you register a domain name and it is referring to email through which you can do things, but if there's a postal service on it, but it's used, right? Yes, it is used. Next question related to instruction number 47 is registration of domain of the third and subsequent levels. In other words, under the existing instruction, if these domains are referring to the site, then in this case we need to register or must have the contact data of the administrator of the site. We believe, in fact, that it would be better for us to follow the international practice according to which the owner of the second level domain have the right to decide themselves how to use their domain, and by the owners of the domain of the third and subsequent levels. There is yet another interesting thing related to impossibility to cancel the registration of domain. Like, for instance, any subject who registered domain, according to the instruction, there is no way for them to cancel this registration. like to annul it. And then a person or so such small things as calendar days are foreseen by the instruction, but it's better to fix it in the calculation of the working days instead of calendar days. So there is some restriction to the cancellation of domains if it ends up in the say holidays or day offs. If domain is used mostly on the weekend, then it ends up on the first working day, according to our instruction. As a result, we have a huge problem like New Year holidays, when by 2 weeks all the domains can be canceled, and then all of a sudden they are canceled at one fell swoop. So they are fighting for the freed out domains. So I think it's wrong. The domain system must work according to an ideal time, like trains, for instance. If a train, for instance, is coming on Saturday, it must stand on the way station and wait until Monday. Same thing should apply here. Unified time must be applied in the system of registration of domains. So far, we don't have a situation when other things are not properly described, like in our economic code, the calculation done is calendar days, but in other instructions it mentions working days. So now it's calendar days. Then all weekends and holidays will end up there. From the standpoint of an owner of domain, I think it's good. If I arrange a party before the New Year's holiday, I know that my domain is not going to be taken away. But on the other hand, I encountered a situation off top, just a off-top comment from my side. When I received a loan from my card, I was repaying the loan from my card, and the system calculated that I repaid the loan only 2 weeks after that, because their software is living for New Year's holidays together with their software. And so I had to pay penalty for that. I said, wait a second. They said our software works like this. Turns out that they also calculate it by working days, and they don't calculate holidays. So it's not necessary, because it can really have bad consequences. But there was a question about the calendar days as far as they apply to the registration or violations. We have, for instance, 3 days for the answer to the administrator of the domain. If they fail to submit their answer, then they have 7 more days for a repeated answer. And in case of other subsequent days they don't answer us, then we initiate a procedure of cancellation of this domain. Here the dates can affect this process as well. So if we try to use counter arguments, then domain, when delegation is lifted from domain, then domain is not removed. Removal of delegation means you no longer use DNS. A domain is no longer sending addresses. It will be empty page, no fold. Or sometimes the screensaver of an administrator telling you go to administrator, but it remains to be in the system. Now, an administrator finds it interesting, they can run it, return it back very soon. But if they initiate a deletion of domain, then if they initiate it, then they can go wherever they want, but the domain will be gone. It will be gone, meaning what? Any notes of it will be deleted, and anybody can own it, can buy it up. I'm sure you have domain hunters as well. When domain was in a high link of high line of the search engine, then its registration remains to be there. Its visits are not dropping, and it has a certain value. That's why we have good domain name hunters. Thank you. Last one is not that important. The last slide, or one before last, decree number 46. In Belarus, a long time ago, special presidential decree number 46 was adopted, but it establishes the term of 31st of December 2018, very soon, actually. What is this edict or decree about? This decree implies establishment of a Republican cloud platform based on the Republican Center for Data Processing. And the Republican Center for Data Processing, according to this decree number 46, belongs to the company Belarusian Cloud Technologies, which in fact are a state-owned company, because more than 50% of them belong to the state. And according to this decree, it is suggested to do transition until December 31st of state authorities, state-owned organizations and entities where the final decision is made by the state, to the resources of the Republican platform. This way, we have very interesting situation when all the state organizations and economic entities regulated by the state who are hosted in private companies, not necessarily in host buy, but maybe in other hosting providers, they do the transition until the end of the year to the state hosting. The hosting, which is offered by the cloud technologies company. We have analyzed this because state authorities started to approach us, asking us to explain whether we really need to do this transition. This is quite a costly procedure, because for this we need to move about all the resources. And the Belarusian technologies don't have so many specialists who would be capable of correctly do this. We believe that, in fact, we're talking about direct interference of the state here through a legal act into the activities of private hosting providers, so that part of the services and some of the revenues from the hosting moved to the state side. If there are any comments about this decree number 46, I can answer them, but we have prepared a mental reminder for ourselves when we say that in this legal act there are no words must move, are obliged to move, or need to move. In other words, there is no strong words about this. Moreover, if they fail to do so, then the direct responsibility is not foreseen here, no direct liabilities. There might be some disciplinary liabilities, but no administrative liabilities for this. Basically, this is all I wanted to tell you. Thank you. Can I also provide my comments on your last note on decree number 46? Because as a person which specializes on competition on the one hand, on the other, I've been working for many years with the business. I must say that the existence of such a norm in the edict does not violate any provisions of the law, even the law on prevention of development of competition, because it directly says that the state authorities are prohibited to adopt such acts and norms where some economic entities would be in unfair position vis-a-vis other economic entities, with the exception of the situations which are foreseen by the presidential edicts. So we can say that in this case we can clearly be talking about social injustice, but if it were a norm established by a council of ministers or other agency, then we would be saying that it is incompetitive and then it's in violation of other provisions of the legislation. But in this case, unfortunately, no matter how focused it is on the state-owned companies, it's not in violation of the provisions of the legislation. When we show other arguments, we think we can do something, but everything is legit. I will agree with you on this, that there are no violations of the anti-monopoly legislation, but still I try to follow humanistic and non-discrimination principles, and I think there are questions starting from fulfilling the principles of the civil law and norms of constitution, because it's clear that in Belarus the court does not directly make decisions based on the principles of the law or the norms of constitution, but I still believe that there is some legal collision. But otherwise, it is true that the law on anti-monopoly legislation does not violate the anti-monopoly legislation. I'm not only talking about anti-monopoly legislation, but following the principle of the general theory of law, the fairness and other things. Of course, the court decisions are not taken into account. Can I interfere and ask a question? I understand that, just to find out, the hosting only on territory of Belarus, the cloud hosting also is included here or not? The cloud hosting for the owners of the site. Cloud hosting, the main person who provides the service must be located on Belarus, right? And the hosting itself, this is true about companies who use resources in internet. So this norm does not cover all, and the existence of just calling card sites which do not really sell any goods and services, such requirements should not apply. But here we have a different question, when in real life there are such domains can be registered only by INS, provides such information including hosting from Belarusian suppliers. And in conclusion of our session, we can get some comments from organization of analytical center, but it didn't come from analytical center, but in Ministry of Information. Can you please describe why this happened? So this, when Belarusian hosting providers have this hosting name. Pavlish, please also explain this, because
Нет, это не в 60-м указе прописано.
It's not decree number 60. And what's bad about this? You're supporting domestic producers, but it's not based on the legal provision, because here when a local representative is a bit outraged that the norm of the law provides some preferences, but when we're talking about unwarranted preferences, which in principle are playing to the hands of the original hosting provider, then nobody cares about that, right? The fact that whatever is done by the states, everything legit. So your position is clear here, but this is not the position. What is your position? We're saying that the Belarusian subjects of hosting providers are disgruntled with the norm of the law in presidential edict because it's not really fair for them. At the same time, they consider the existing practice based, not really based on the law, but providing preferences to it in its business activities as quite legal and legitimate. Dear audience, see, when discussing such things, we see have so many conflicts in how to regulate the original regulation of internet.
В принципе, будет какой-нибудь комментарий?
Честно говоря, не знал, что существует такая проблема, что при регистрации доменных имен существуют требования к указаниям DNS наших хостинг-провайдеров. И никаких ограничений нигде не предусмотрено. Поэтому я, честно говоря, не готов особо ответить на этот вопрос.
I don't know whether you can answer this question, because this problem was never mentioned. There is norm about describing this, but maybe after the session I will tell you more about it in person. Sergey is so well aware of this, it's not a problem for him. So basically there is subject but no jurisdiction. In fact, if there is such a proposal, we can introduce such a provision. Why not? Dear colleagues, thank you very much. Thank you for being with us until the end of the forum. Thank you for listening. Thank you for asking questions. I hope that you will bring back with you, aside from the gifts given to you in plastic bags, something also intangible but equally useful, and you will continue showing interest to such fora in future, and will be active users and participants of them. Thank you, speakers.